Hello, everyone, and welcome. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin, LLP, here to talk to you today about employment law, about workplace rights, any issues that arise in the workplace, whether you're dealing with a termination of employment, or maybe your boss is trying to change your terms of employment. Maybe you've been temporarily laid off from your work. Maybe you're dealing with bullying or harassment in the workplace. Really, any and all questions related to your work, related to your job, we are here to answer. This is a live Q&A. We're here to take your questions right now on the spot. I'm on the hot seat. And I've been doing this for quite some time now, both as an employment lawyer and also these live streams. So for those of you tuning in, feel free to throw the kitchen sink at me. Really, any issue that you're dealing with, go ahead and type your question into the chat, post it online, and I will make sure to get to it in the next half hour. As well as answering questions with respect to employment law and, of course, your work, we can also deal with any questions related to disability insurance. If you're employed and taking a medical leave of absence, if you've been injured at work, or if you've been injured outside of work and you need to take some time off, we can certainly talk about the laws around taking medical leaves of absence, as well as applying for and receiving disability benefits. Many of you out there that have kind of regular full-time jobs have disability benefits coverage through your employer's group benefits plan. And so if you are unable to work because of an illness or an injury, you would have access to disability benefits. A lot of times employers cause problems for employees in that respect, and insurance companies as well sometimes will give employees the runaround when it comes to disability benefits. They will either deny valid claims or ask for unreasonable information, or just generally speaking, give people a hard time when it comes to disability benefits. If you are dealing with that kind of situation, again, go ahead and post your question. More than happy, more than capable of answering any disability insurance related questions. That is what we're here to do. Before I get into a topic that I wanted to chat about today, as our longtime listeners will know, I typically want to touch on a subject or two before we get into the questions. I first want to give you our contact information. If perhaps you're too shy to ask your question online, or maybe it's a complicated one and you need to have a chat privately, confidentially, off of live stream or off air, go ahead and contact us. Main way to get a hold of us, visit our website, employmentlawyer.ca. Of course, all of our contact information, phone number, email addresses, individual lawyers' contact information is all there. We've also got a ton of resources that you can find on our website. Again, it's employmentlawyer.ca. You can see it on your screen right now. We've got a ton of articles. We've got what you need to know from an employer's point of view and an employee's point of view when it comes to basics of employment law. We have a ton of news articles and video clips. Another way that you can get a hold of us, you just saw it on your screen, our email address. And actually, it's the main way that you can get a hold of us. Send us a quick email, help@employmentlawyer.ca, help@employmentlawyer.ca. Go ahead and send us an email. Give us a brief description of the situation that you're dealing with. If you're terminated, let us know that your employment has been terminated. Again, give us some basic info. How long you've been with the company, what you did, perhaps how old you are. Those are the relevant factors when we're talking about severance and termination. And I promise someone will get back to you if you email us. I will also share our telephone number. If you want to give us a call at the office, I believe it's toll-free as well. You see the number on your screen right now. Go ahead and give us a call. We have an entire intake team standing by, waiting to answer phones, field questions about anything workplace or disability insurance related. If you can't get a hold of someone right away, leave us a message. Again, I promise someone will get back to you. Okay, that's the contact information out of the way. Let me touch very quickly. I see some questions coming in already, guys, and that's absolutely great. Rihanna, JBK, Michael, thank you so much for asking those questions. If you could just sit tight, I will get to them. And in the meantime, if those of you just tuning in, Again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin. This is a live employment law Q&A, live right now on your screen. I am here ready to answer any and all employment law related questions. If you're dealing with any kind of situation at work, really anything under the sun, if you just have a bad feeling about how your employer is treating you, or if you're worried something's going to happen, if you feel like you might be let go, if you feel like your employer is going to try and demote you or change your position or lay you off or pass you over for a promotion, again, go ahead and post your question. I promise I will get to it. I promise I will be able to shed some light on whatever difficulty you're facing. And oftentimes, after people speak to us and ask their questions, they feel a heck of a lot better about their situation. And so again, don't be shy to ask your question. Let's line up a good number of questions and I will get to them over the course of the live stream. But first, as promised, I wanted to talk about a matter that came across my desk actually earlier this week. Spoke to a very nice lady, and I think it's a good example of situations that we're seeing more and more nowadays, and that I wanted to share. It could be a good heads up for our viewers and listeners out there. Spoke to a very nice lady. She was in her early 50s and had recently changed jobs. So she had been with her new employer for just under 2 years. So she started not long after the pandemic began, actually, and she was working remotely for this organization in a pretty senior role. She was a manager with the company, relatively small company. And unfortunately, the company had most recently fallen on hard times, and she was let go from her employment. Her employment was terminated, and her employer offered her, when she was let go, only 2 weeks of severance. 2 weeks effectively being her minimum entitlements under the Employment Standards Act. And, this lady, to begin, of course, was very upset with the fact that she was being let go. So she was already in a very fragile emotional state, as of course all of us would be when they find out that they've effectively lost their job and they have to now start from square one and start on the job search again and go through that process. Instinctively, during the termination meeting, she saw the 2 weeks that the company had offered her, and to her credit, she asked the question. She effectively said, 2 weeks doesn't feel really like much time for me to go out there and find another job. Are you sure this is all you owe me? Wouldn't you owe me more severance? And her employer responded by saying, well, no, you signed an employment agreement when you started working with us that actually limits your severance entitlements. And so we only owe you 2 weeks. And this lady believed that at face value, said, okay, I guess my employment contract limits my severance entitlements. She took, those documents home. She packed her stuff and then reached out to us. And really, she reached out to me wanting to have a chat, effectively having already come to terms with the fact that 2 weeks is the best she's ever going to get out of the situation, that the company was correct in saying that 2 weeks is all she's ever going to be owed. And she really just wanted somebody, a professional, an employment lawyer, to kind of double check that and make sure that it was correct and effectively give her the blessing to accept the 2 week offer and move on with her employment. And so when she reached out to me, she effectively said, Alex, I know my contract limits my severance entitlements. I just want you to tell me that that's correct, and I'll be moving on with my life, and hopefully I could find the job sooner rather than later. And so I looked at the contract. And lo and behold, the termination language that was in that document actually didn't limit her severance entitlements to only 2 weeks. It wasn't written well enough. It wasn't enforceable. And so I actually had pretty good news for this lady. I told her, well, hold on a sec here. Your employer may think this is enforceable, the contract that is. Actually, it's not. Termination language in an employment contract needs to be very, very carefully drafted, very carefully worded. Even the use of a wrong word or a wrong phrase could render the termination provision in an employment contract unenforceable. And that was exactly the case in this lady's situation. The employer had effectively messed up, and the language in her employment contract didn't limit her severance entitlements. And that is a major, major deal, because this lady wasn't owed just 2 weeks of severance. Because of her age, again, she was in her early 50s, because of her managerial position, and even despite her only 2 years of service, she was likely looking now at a severance package in the range of 4 to 6 months, not weeks, months. So compare the company's original position of, well, you're only owed 2 weeks of pay, that's the best you're ever going to get, to effectively having an additional 4 to 6 months of severance to hold her over so that she has the proper time that she needs to go out there and find a new job. This lady didn't know that. If she would have taken her employer's word for it, she would have been passing up on that additional severance, and she would have accepted pennies on the dollar as compared to what she is actually owed. And so this is a good, of course, lesson for all our listeners and viewers out there. If you have been let go from your job, you can be a short service employee, you can be a long service employee. The basic lesson is this. As much as you trust your employer, as much as you've had a good experience with your employer despite having been let go from your job, please do not take your employer's word at face value when it comes to severance offers. Oftentimes, employers either don't know what a proper severance analysis is for an employee, or they, of course, want to pay as little as possible, and so they purposely mislead employees with respect to their severance entitlements. In this lady's case, I don't think the employer was doing this on purpose. I think they were just under the impression that their employment contract was enforceable when it actually wasn't. And so I don't think they were doing this purposely, but they didn't know. And so it was wrong for this lady to take her employer's word for it and just, assume that her severance offer was correct. Her employer was actually grossly incorrect with respect to that. And so again, don't assume what your employer is telling you is correct. If you've been let go from your job, if you've been offered a severance package, make sure that you speak with an employment lawyer. It could be us. It could be any other employment lawyer for that matter. But make sure you get professional advice like you would for any other major milestone in your life or in your career. You need professional advice. And when it comes to severance, you don't want to speak to the Ministry of Labor. You want to speak to an employment lawyer that knows what they're doing and knows the true way that severance is calculated. And that is based upon an employee's age, position, and years of service with the company. It's not going to be just a couple of weeks. It's not going to be a couple of weeks per year of service either. Oftentimes, it's going to be significantly more. We're going to be now working with this lady to get her proper severance entitlements. I actually don't expect it's going to be particularly complicated. The law in this area is not particularly complex. And so we'll be working with the company to make sure that this employee gets what she's owed. Again, if you've been let go, make sure to reach out to us. Make sure to contact an employment lawyer. Let's have a chat about your severance offer. If the severance offer is reasonable, great. We'll tell you it's reasonable, and you can go ahead and accept it. Oftentimes, however, what we see, the vast majority of the time actually, is that severance offers are severely deficient, as this lady's was. We're literally looking at a difference of tens and tens of thousands of dollars. That's how costly signing off on a severance offer without getting advice can be. It can literally cost you tens of thousands of dollars. Okay, guys, I will get off my soapbox there and start answering questions. Again, I hope you appreciate these little lessons and stories on our radio shows and TV shows. We call this the case of the day, or the case of the week, or the week that was is what it used to be called. But I like to do this on the live streams as well. Of course, it's a different audience and different viewers. And again, hopefully some of these stories will cause you to have another think about how you deal with your employer. And ultimately, in this case, if you're let go from your employer, what you need to do and what you shouldn't be doing. Okay, let's start with the questions. Everyone, Raina was first in line on Facebook. Raina, thank you for your question. And you ask, can you be denied vacation due to your company being understaffed? My manager says that they're trying to hire someone, but as a result, no one is allowed to take any time off. Interesting and quite good and quite topical question, Raina. We've definitely seen, and I'm sure those of you who are paying attention see in the news that there across many industries, there are labor shortages, companies are short-staffed, and that obviously puts a strain on existing employees. Raina, the general answer to your question is that employers are allowed to dictate when an employee can take vacation or when they can't. The employer has a say in the matter. You cannot just unilaterally say, I'm taking a vacation this week or these days, whether you like it or not, employer. It's not the way it works. You need their agreement. And so if your employer is saying, hey guys, for the time being, please don't take any vacation, we can't afford it, it may be the case that you might have to bite that bullet. Now, there is, of course, a line in the sand there. An employer cannot be terribly unreasonable. You cannot go, at the very least, number one, under the Employment Standards Act, at least in Ontario, an employee is required a minimal amount of vacation per year. And I mean the actual time off, setting aside the fact that you're actually owed pay for that minimal vacation. You actually have the right to take a certain amount of vacation per year. And so within that year, fine, your employer can potentially dictate when you can take it and when you can't take it, but you are entitled to the time off. At the very, very least, employees are owed a minimum of 2 weeks of vacation time per year. If you are a 5-year or more employee of the company, that rises to 3 weeks. You are also owed vacation pay for that time. So keep in mind that vacation can be paid. Vacation pay, by the way, can also be paid on your pay stub, on your regular pay. So rather than paying you for that actual week, you can just be receiving a small amount. It's usually 4 or 6%, which is 2 or 3 weeks on your pay stub every week, and that accounts for your vacation pay effectively. So Raina, the short answer is I think you need to work with your employer here most likely. That said, if you haven't taken vacation the entire year, you should be telling your employer, hey, I know I'm entitled to a minimum amount of vacation at least. I have to plan this vacation soon enough and sooner rather than later, and your employer has to play ball. These things like vacation or overtime pay, or if your employer isn't paying you the proper amount and you think there's a wages issue, these kinds of items, it may very well be useful, Raina, to contact the Ministry of Labor and have a chat with them about it. Oftentimes, they can come in, investigate, and make an order if they need to. It's quite frankly, the few occasions in which the Ministry of Labor, at least in Ontario, can actually be useful. Keep in mind, the Ministry of Labor should not be dealing with any severance issues or any termination issues. You should not be going to the Ministry of Labor when it comes to termination or severance pay. They will oftentimes get those kinds of things wrong and actually mislead you with respect to what your severance entitlements actually are. The Ministry of Labor cannot deal with termination or severance pay issues, at least they can't deal with your full severance entitlements based on your age, position, and years of service. Don't go to them for severance. Go to them for things like vacation pay or like overtime pay or like wages. And so, Raina, if you continue to have a dispute with your employer about this, again, don't be shy to contact the Ministry of Labor. You have minimum vacation entitlements, but again, your employer can dictate when you take that vacation and when you can't. Okay, JBK is next in line on YouTube. JBK asks, can your employer make you get a flu shot? Another interesting question. That's excellent, guys. Thanks so much. I would say, and we can draw an analogy here, of course, to the COVID-19 vaccine, and that has been the topic of the year, really, or the past couple of years. Now, in the employment law world, can an employer mandate that you get the COVID vaccine or not? And again, I think an analogy can be drawn to the flu shot. I do know, JBK, that in some healthcare settings, and I think this applies particularly to unionized workplaces, and I'm thinking specifically about nurses' union. I've seen a good number of nurses' unions where their collective agreement, meaning the contract of employment between the employer and the union, requires employees to get vaccinated against the flu or to get a flu shot every year. And so it could potentially be the case, to answer your question, that a flu shot is effectively a mandatory term of employment. Now, that's probably the exception. To be clear, I think in most cases, it doesn't really make sense for an employer to be mandating a flu shot. There's probably no real precedent for that in your particular employment. If you work in an office or in any other setting for that matter, I don't think an employer can force that upon you. It doesn't sound to me like it's a necessary health and safety policy that an employer needs to have. There's been lots of debate, of course, over whether an employer can mandate a COVID-19 vaccine, or, as time passes now, whether they can mandate booster shots, maybe a third dose or even a fourth dose. That is, I expect, going to become a live issue. Employers are going to be mandating third and fourth, and maybe even fifth and sixth shots against COVID-19, and we will ultimately see whether those are enforceable or not. Quite frankly, my personal opinion is that it is probably overkill for an employer to be mandating fourth and fifth and sixth booster shots for COVID-19. But nonetheless, it will be a case by case and industry by industry analysis when it comes to that. JBK, if you're in the healthcare setting and maybe you're a unionized employee, you want to look at your collective agreement. It could be the case in those circumstances that your employer may be allowed to require you to get the flu shot. Otherwise, I highly doubt it. But thanks for the question. It's a very interesting one and a very good one. All right. Michael here asks, Michael Martin on Facebook asks, can an employer force me to work overtime or stat holidays? I'm in Ontario. Very good question, Michael. The first place, the general answer to that question is no, unless your schedule requires you to do so, or unless your employment contract requires you to do so. So two things. Number one, if there's anything in your employment contract or an employment agreement, or if you're unionized, in your collective agreement, in the agreement between the union and the employer, that requires employees to work overtime or requires employees to work stat holidays, then you have to play by the rules of the game, by the rules of your employment contract. So that's the first place I would look, Michael. Look at your employment agreement. Look at your offer letter. If it says in there that you have to work overtime or that you have to work stat holidays, guess what? You've got to play by those rules. Secondly, Michael, precedent matters. In other words, your implied terms of employment matter. If historically you have always worked overtime, if historically you have always worked stat holidays, or if there was an understanding between you and your employer that you would work those hours or that you would work those days, then your employer would have the right to hold you to that implicit understanding. I'll give you an analogy. Temporary layoffs are a situation we oftentimes deal with from an employment law point of view, because inherently temporary layoffs are not legal. There's actually language about temporary layoffs in the Employment Standards Act, in legislation in Ontario that deals with temporary layoffs. But again, the starting point rule is an employer cannot force an employee to take a temporary layoff. The employee has to agree. Now, there's two ways to agree to that. It can either be written into your contract. Michael, this is, again, exactly analogous to your situation. A temporary layoff term could be written into an employment contract, or if you have historically or previously agreed to temporary layoffs in the past, your employer then has the implicit or the implied right to lay you off in the future. It's actually the danger, the main danger of agreeing to a temporary layoff once. Once you agree to a temporary layoff once, your employer may very well have the right to lay you off again and again and again. And the second, third, or fourth time, your employer actually again, can force you to take the temporary layoff, even though that second, third, or fourth time you don't want to accept it that time around. Michael, I think the situation, again, is similar in your case. If you've already worked overtime or stat holidays, and that there's just kind of that implicit understanding between you and your employer, you know what? You might be stuck with it unless you have a really good excuse. Or if it's in your contract, again, you might be stuck with it. I'll insert one more caveat, Michael. If you can't work overtime, and I've seen this plenty of times, and actually this causes disputes between employers and employees all the time. If you can't work overtime hours, perhaps because of a potential medical condition, maybe you have some health issues and the overtime hours just really burn you out and really set you back physically or even mentally. Or, for example, if you're elderly, if you're an older employee and overtime again just beats you up physically or beats you up mentally, and it's really just not doable. It's not feasible. It causes you too much pain, too much suffering yourself. There is an answer to that situation. Go to your doctor. Speak to your doctor about how that overtime impacts you either physically or mentally or both. Get a note from your doctor saying that you can't do overtime hours, and that provide that note to your employer. Your employer has to respect that accommodation. They cannot force you to work overtime hours if you have a medical note saying you can't do it. So a medical note could save you in a situation like that. Of course, it has to be legitimate, right? You can't just get a fake note and pretend that you can't work overtime hours. But oftentimes that's the case. Oftentimes employees are either just burnt out mentally or burnt out physically, and they just can't commit to those overtime hours. That might be a great way to solve that problem. And again, your employer has to accommodate you in that respect. They can't force you to work overtime hours when you have a legit medical note saying you can't do it. All right, next up in line, Leonella asks, I was on a medical leave for about a month and was finally cleared to return to work. When I informed my boss, they told me they didn't have space for me to return as they had hired a replacement with a longer contract. Can they do this? My word, I'm very sorry to hear that, Leonella. That raises massive red flags for me. That is a major, major problem. Let's start with kind of the preliminary and most basic of points here. An employee is absolutely allowed to take a medical leave of absence. You cannot be punished. You cannot be demoted. You cannot be fired because you have to take a medical leave of absence. This is assuming, of course, that it's a legitimate medical leave where, again, you get a doctor's note and you pass that doctor's note on to your employer. Your employer is allowed to ask for evidence that you're taking a medical leave. It doesn't have to be much. It could be a very brief note saying employee unable to work for medical reasons from this day to that day. That's all they need to know. The employer doesn't need to know what condition you're dealing with. It doesn't need to know why you're taking a medical leave, what the diagnosis is, but they do have a right for some evidence that you're actually on a medical leave. And again, that comes in the form of a doctor's note. Now, once an employee is cleared to return back to work, when they're ready to come back to work from a medical leave of absence, which again, they're legitimately allowed to take, your employer has a legal obligation to return them to work. They cannot tell them, Leonella, like your employer just told you, that, oh, sorry, we filled a position, there's no position for you. They cannot even try and change their position and say, oh, well, that position's gone, will you accept some other position? You have the right to return to the same terms of employment that you left. Same position, same hours, same pay, same location, period. Full stop, no ifs, ands, or buts. And so, Leonella, what your employer has done here by refusing to return you back to work and basically telling you that you've been replaced is, number one, they've actually terminated your employment, right? They're not allowing you to work when you're medically fit and able to do so. That's a termination. And number two, they've made that decision because, of course, that you took the medical leave of absence. They've effectively said, well, because you left, we replaced you, and now you don't have a job. That's discrimination, Leonella. Not only are you going to be owed severance because it's a termination, you are also going to be owed severance because they let you go as a direct result of you having taken a medical leave of absence. That is going to entitle you to additional damages over and above your severance entitlements for the way in which you were treated, for the way in which you were terminated, which again is discriminatory. You cannot, for all our employers listening out there, anybody in HR or in management, please, you cannot treat employees that take medical leaves this way. They have a right to take a medical leave of absence. They cannot be punished for it. They cannot be replaced in their job. They can be replaced temporarily by all means, right? You have to fill the gap if the employee is not actually at work and working. But once that employee is ready to come back, you have to bring them back to the same position. And any delay and any difficulty you give an employee in that situation will be viewed as discrimination and will potentially result in, again, two heads of damages, as we call them: severance and discrimination, and additional damages for discrimination. So Leonella, if you haven't already, and I hope that you have, give us a call, send us an email, speak with an employment lawyer, speak with one of our lawyers here, and I promise you we will be able to resolve your matter for you. We will leave it at that, guys, because we're out of time. Thank you so much for joining us. Thank you so much for the great questions today. If I haven't gotten to your question today, we have another live stream at, I believe, 1:30 Eastern time tomorrow with my colleague and friend, Samara Belitsky. She will be more than happy to answer your questions. Go ahead and tune in at that time and go ahead and post or repost your question there. Until then, guys, thank you all so much. Have a great rest of your work week and a great weekend. And please tune in for another live stream next time we do this. As always, take care, everyone, and so long.